For our jurisdiction, we chose Louisiana, so the first thing I'm going to do in Westlaw is change the jurisdiction. So the first question is, can Mark argue that Jason gave consent? So I searched consent and assault in parentheses, and I scrolled down and came across this tort. The tort reads, while consent vitiates an intentional wrong, consent to some extent of intentional harm is not consent to an entirely different and more serious level of conduct. So while I read this, I checked the footnotes, and it's highlighting consent and assault because those were our keywords in our search on Westlaw. So I clicked on this case that's linked after as to consent to fight. And I came across this case, which was at the Court of Appeals in Louisiana, so it's binding. And I scrolled down to the second head note and came across a person who engaged voluntarily in a fistfight that forms a basis for a civil suit for an alleged battery cannot complain to the court simply because he suffered the worst of it in absence of unusual circumstances. So this is basically saying that Jason can't complain to the court because he suffered the worst due to Mark hitting him in the face and not in the stomach. And that will be brought up when Shay explains the authorization of the stomach punch compared to the punch to the head. And so this made me curious about the intoxication part, so I ran another search on Westlaw with assault, impairment, and consent. And I used impairment instead of intoxication because I couldn't find much on intoxication, so I used impairment instead. And I came across this case, which is Cole v. State. This case is about a correctional officer who is sued for injuries alleged sustained in a training exercise. So I went down a little bit to the head notes and read number 7, which is about assault and a battery, and clicked on 2 cases cited in this head note. So the first case I clicked on, I did not use because at the top in all caps it says unpublished opinion. So I used the second one, which is Bernstein versus Powerhouse Gym. So this case is about negligence in a kickboxing exercise where the martial arts student brought action against the martial arts school and the owner for injuries suffered during the kickboxing exercise. So I scrolled down as I was reading this case, and I came across this right here, and it says, when a person voluntarily participates in an altercation, he may not recover for the injuries which he incurs, unless force in excess of that necessity is used, and use is not responsibly anticipated. The use of unnecessary and unanticipated force vitiates the consent. So this made me curious about unnecessary force in the state of Louisiana. So I ran another search about unnecessary force. Just to see if I could find a statute that explained it more. So I ran unnecessary force in Louisiana jurisdiction, and I came to the left side of Westlaw and clicked on statutes and court rules. And I came across number 19, which is use of force or violence in defense. And came across this right here. A person who is not engaged in unlawful activity and who is in a place where he or she has the right to be shall have no duty to retreat before using force or violence as provided in this section, and may stand his or her ground and meet force with force. So this brought me to it depends, because the force of the hit could possibly cancel out the consent. If the court finds that it was unnecessary force which vitiates the consent, the plaintiff could make a case justifying that the use of force was unnecessary, would reprimand to yes instead of it depends.
So when I first started my search, I put in 2 different terms or 2 different advanced searches into the search bar. So for the first one, let me just put it in, and then I'll explain why I decided to search 2 different things. So on this go around, you're going to see that I just decided to include all of the important terms and just threw it all in there. Once I finish typing it, you'll realize why that wasn't so helpful. Okay, so as you can see, this yielded 10,000 results. So that's 10,000 cases for you to go through and figure out which one fits the best. So once I came to this conclusion, I was like, 10,000 is way too many cases for one person to go through or even like get to the bottom of what you're even looking for. So I kind of refined my search a little bit, took out over half of the line that was there, and this is what I was left with. And I know, Ms. Johnson, she said usually she doesn't prefer the but not sign, but in this case, it was more than helpful because if I hadn't used it, it would have yielded like way too many cases that was irrelevant to the content in which I'm looking for. Especially when we're talking about assault and consent, it's important that it's important that we specify that we're not limiting it to like sexual assault and all of that stuff. Alright, so this refined search brought me 158 cases, so that's a lot better considering the 10,000 that was just before me. So I think the ones that I used was this one. This is going to be the first one that I refer to. It's Cole versus State. Okay, so I'm not going to get into the gist of the facts of the case itself. I just want to, more importantly, emphasize the head notes. Viewing the head notes, it saves me a lot of time when I'm trying to research certain things and cuts out time by me not having to go through the lengthy opinions and everything. Alright, so let me see which one I want to get into first. So head note number 5, it's in regards to the assault and battery itself. It says consent as a defense to tort of battery may be expressed or implied. If implied, it must be determined on the basis of reasonable appearances. So let me specify really what my question is because I realized that I didn't really get into that. So let me rewind for a little bit. Okay, so my question is, could Jason counter the fact that he only authorized a stomach punch as a counter against consent? And that's in my own words, so. Alright, so like I was saying, consent as a defense to tort of battery may be expressed or implied. If implied, it must be determined on the basis of reasonable appearances. So this says that there are 3 other cases that cite this head note, so it was important for me to dive a little deeper and review these 3 cases and figure out which one I wanted to include. But before I do that, I just want to point out these key numbers. Later on, they're going to be a little bit more relevant. Once I review these other cases, I can really focus on the key numbers. But I do want to not neglect these. Alright, so Gulliet versus Gulliet is where consent in terms of assault and battery is discussed in. So this is really the one that I really referred to. I didn't really pay close attention to the other 2 because this one, it really stuck to me. So this was a situation between 2 brothers. They got into it or whatever, or maybe not even that. I think a situation to whereas it was an altercation and one of the brothers got hurt more than they could anticipate. So the thing was, one of them consented to the altercation, but did he consent to the full gist of the assault itself? Sorry. So like I was saying, I like to pay close attention to the head notes. It saves me time. So in this case, evidence was sufficient to support a finding that the family member consented to it. So consent was the main thing. I forgot to include that in this other case, the court held that the consent wasn't established. So I think that's something that I need to signify, that in order for consent to be used as a defense to tort of battery, it must be not only implied, but you also have to make a case of it. You have to prove it, and the proof must be substantial. So let me go back. All right, so in this case, in Gulliet versus Gulliet, the court held that the evidence was sufficient to support the finding that the former member, which was one of the brothers, did actually consent to intentional battery by his brother. So let me go back to the head notes and kind of go into depth of the importance of the consent. All right, so I know I kind of started on this, but I want to go ahead and finish it out. It says evidence was sufficient to support finding that former member of family farming partnership consented to intentional battery by his brother, such that brother was not liable for injury sustained by former member in altercation that occurred after former member attempted to remove crawfish boat from brother's property at the peak of crawfish season. So, former member admitted that he had no immediate use for the boat, yet took it anyway. Probably being petty, but he admitted that he immediately knew when he started leaving the property and saw his brother coming towards him that there was going to be trouble. And upon arriving with the boat in tow, former member voluntarily exited his vehicle and moved and walked towards the brother, even though he could have gone inside his house or remained in the vehicle waiting for the police to arrive. That would have avoided the altercation, but like I said, despite all of that, he still decided to move forward with it. So that basically is the consent that was established, because he had several avenues that he could have taken to kind of go around engaging in this altercation. It could have been prevented. Instead, he went full head on in it. So consent as a defense can be countered, and the way in which it could be countered is with the comparative fault. It does not apply when one consents to a battery, and that comes from the Louisiana Civil Code, Article 2323, Section A. So consent precludes comparative fault, which basically levels any claim or cause of action or any recovery that one would try to take. And like I said, basically this is a defense to consent. And then in Head Note 7, it goes basically into that in a little more depth. It says, when a person voluntarily participates in an altercation, he may not recover for the injuries which he incurs unless force in excess of that necessary is used, and its use is not reasonably anticipated. So that's something that Bailey mentioned in her part of the presentation. She talked about force in excess, and also whether or not the use was reasonably anticipated. So all of that ties into consent and comparative fault, and whether or not you can apply one or the other in the situation. All right, and this head note says the defense of consent operates as a bar to recovery for the intentional infliction of harmful or offensive touching of the victim. So basically, this just says that when you provoke situations, you egg it on, you initiate it. So that is consent. Once you go ahead and take that step towards, actively engaging in it, you are consenting to whatever comes next. All right, so, and then I want to also, just for the sake of being thorough, I want to go over head note number 9. It says, when two parties expressly or impliedly agree to fight, the consent of one is not vitiated, such that he or she may recover for injuries merely because the one or the other strikes the first blow. So, like I said in the beginning, that was basically when I was talking about whether or not you can recover from the injuries that you incur when you are in the altercation that you consented to. The answer to that is no, because you consented to it. All right, so to refer back to my question at hand, let me go back to it. My question was, could Jason counter that he only authorized the stomach punch? My answer to that would be no, he cannot counter that because he consented it. And once you consent to engaging in an altercation like this one, you consent to everything that comes with it. And a disadvantage to this would, like I said, be the comparative fault doctrine, and that just basically provides the premise that both individuals will be held accountable, so there will be no bar for recovery for neither one of the parties. So it's really just, covering both ends of the table. It's saying that both of you take responsibility, so you can't try to go sue someone if you both take responsibility for it. It kind of negates one another. All right, so there's one more question that we need to answer, and Casey is going to get that covered. So let's see what she has.
Okay, so my question is, can Jason say his intoxication negated his consent? And to start out, I typed in assault and drink, but I did it this way because we wanted anything that involved drinking, drunk, anything. And consent, and type that in because I wanted to find cases involving these factors to see what the final verdict would be in similar cases. And so I went over here and clicked cases only. And then scroll down to number 10, White versus Guild. And this case is basically about a bar fight. And the plaintiff tried to argue that his consent to the fight was canceled out because of his intoxication. But the court said, we find further no validity in the plaintiff's contention that his consent was vitiated by his intoxication, although the record is clear that both plaintiff and defendant had been drinking heavily on this occasion. Both were clearly aware of what was happening around them. And on this case, it says that it is clear that they were both drinking heavily. With our case, our facts just say they were drinking. It doesn't necessarily say that they were intoxicated or that they had been heavily drinking, but in a case where it was confirmed that they were heavily drinking, it still was not an excuse that canceled out his consent to the fight. So my answer is no, Jason couldn't use the excuse that his possible intoxication negated his consent. However, if more facts came up and it was proven that they were intoxicated, I found this statute, so we're just going to go back, and I'm going to go over here to statutes and court rules, and then I'm going to go down here to the statute for intoxication, and right here it says, the fact of an intoxicated or drugged condition of the offender at the time of the commission of the crime is immaterial except as follows, and we're going to pay attention to number 2 because it's relevant to our case, where the circumstances indicate that an intoxicated or drugged condition has precluded the presence of a specific criminal intent or of special knowledge required in a particular crime. This fact constitutes a defense to a prosecution for that crime. So, if it did come out that they were drinking, Mark could argue that there was no criminal intent before the drinking occurred, that it all happened after the drinking and was a result of them drinking together and all that. And with applying that, it would mean that Mark would not be found at fault. So the court would more likely grant the motion to dismiss unless Jason could prove unnecessary force was used or that comparative fault can be proven.